Why most personal injury cases settle before trial in Florida. If you've been hurt in a Florida car accident, you've probably wondered if taking your case to trial will mean a bigger payout. By the end of this video, you'll understand exactly why most personal injury cases have settled before trial and how that choice can save you time, stress, and uncertainty while still getting you fair compensation. Because if you push ahead without knowing the risks, you could spend years in court, see your expenses pile up, and still walk away with nothing. Trials are unpredictable and risky. Hi, I'm Doug Bernetti, a personal injury here in Florida for over 30 years. And when you file a personal injury claim, one of the first things I tell my clients is that no jury verdict is guaranteed. In Florida, if your case goes to trial, 6 strangers in a jury box ultimately decide what happens. No matter how strong we think your case is, a jury might see things differently. They might sympathize with the other driver or question the extent of your injuries. The uncertainty is a huge factor. In fact, studies show only around 5% of personal injury cases ever reach a courtroom. The other 95% plus settle before trial. Both sides usually want to avoid rolling the dice with a jury if they can help it. A trial could result in a higher payout than any settlement offer, or no payout at all if the jury sides with the defense. That unpredictability often makes settling a smarter bet for everyone involved. The time and cost of going to court. Trials are not only risky, they're time-consuming and expensive. If you pursue a lawsuit all the way to trial in Florida, you're looking at potentially months or even years of litigation before you see a dime. During that time, medical bills and lost wages can pile up. Meanwhile, preparing for trial involves extensive discovery, depositions, hiring expert witnesses, and paying court fees. As your attorneys, we typically work on a contingency fee, so you don't pay up front. But even then, the case expenses, like accident reconstructionists, experts, or medical specialists, can cost thousands of dollars. Insurance companies know this process is costly for everyone. They have to pay their lawyers for every hour spent fighting in court, and those costs add up. By settling earlier, both sides can save a lot of money and legal fees and avoid court expenses. Plus, there's an old saying, justice delayed is justice denied. A fair settlement today may be worth more to you than a verdict that might come years from now and could even get appealed, causing further delay. Settling allows you to get compensation sooner so you can pay your medical providers and move forward with your life. Emotional stress and public exposure. Going through a trial is stressful. There's no way around it. It's essentially a high-stakes battle played out in public courtroom. You may have to relive the accident in detail, be cross-examined about your injuries, or even have your personal character questioned by defense lawyers. Many of my clients understandably dread the idea of testifying in court. Settling a case out of court avoids much of this emotional strain. It's typically handled through paperwork and negotiations in a conference room or over the phone, not on a witness stand. There's also the matter of privacy. Trials are part of the public record. Anyone can sit in the courtroom or read the court filings. All the details of your medical condition, your finances, and the accident become public information. Settlements, on the other hand, are often confidential. We can resolve the matter quietly with no spotlight, which appeals to a lot of people. This privacy can be important for both injured individuals and defendants. For example, companies and insurance carriers may prefer to settle a serious injury case discreetly rather than risk negative publicity from a large jury verdict. Avoiding a trial can spare you weeks of anxiety and let you keep your personal business private. Insurance companies prefer settlements. In a Florida car accident or injury case, it's usually an insurance company on the other side, defending the at-fault party. And believe me, insurers don't like going to trial if they can avoid it. Why? First, trials introduce financial risk. An insurance company might be looking at paying, say, $50,000 to settle your claim, but if they gamble at trial, a jury could just as easily award 5 times that amount. Juries in Florida have been known to award large verdicts in serious injury cases, sometimes far beyond the policy limits, especially if they feel the defendant was clearly in the wrong. The insurer then risks a bad faith lawsuit for failing to settle within the policy limits. Florida law, section 624.155, allows injured parties to hold insurers accountable if they unreasonably refuse to settle a clear claim and a jury later returns a big verdict. In other words, if an insurance company doesn't act in good faith to resolve your claim, they could end up paying a lot more than the original policy amount. Insurance companies are well aware of this. They also want to control their costs. Trial means paying a team of defense lawyers, expert witnesses, and spending weeks in court rather than closing a file. There's even reputational risk. A public trial could expose any unfair claims practices to the light of the day, which insurance companies don't want you to know that. For all these reasons, insurers often come to the table with a settlement rather than let a case reach a jury. They typically only push all the way if they truly believe they have a strong defense or if we demand far more than they're willing to pay. Most of the time, it's simply safer and cheaper for them to settle. As a result, the majority of Florida injury cases resolve through negotiation long before the trial date. Florida laws encourage settlement. Florida's legal system actually builds in incentives for parties to settle. One example is Florida's offer of judgment rule. That's in Florida Statutes 768.79. This law encourages reasonable settlement offers by imposing a penalty for turning down a good offer. Here's how it works in plain English. If the defense makes a formal written settlement offer and you, the plaintiff, reject it, and then you failed to win at least 75% of that amount at trial, you could be on the hook for the defendant's attorney's fees from that point forward. It works the other way too. If we make an offer to settle and the defense rejects it and then we win 25% more than our offer at trial, the insurance company has to pay our legal fees. This fee-shifting rule puts pressure on both sides to be reasonable and not drag out weak positions. The ultimate goal is to reduce litigation by pushing parties to settle when an offer is within a fair range. Another Florida feature is mandatory mediation. In many personal injury lawsuits, judges will order the parties to go to mediation before the date is set. Mediation is a settlement conference with a neutral mediator, and it can be very effective in resolving cases. In fact, a lot of cases end up settling during or soon after mediation, once each side fully hears the other side's positions. Florida courts encourage this because it eases the burden of the court system and often leads to a quicker, mutually agreeable outcome. The bottom line is that Florida law strongly favors resolving claims out of court if possible. At our firm, we leverage these laws in your favor during negotiations. For example, we might send a strategic proposal for settlement that puts the other side at risk of paying our fees, which can motivate a better offer. These legal tools are running in the background on every case, gently pushing towards a settlement and a fair deal that can be reached before trial. Quicker compensation, certainty, and closure. Settling your personal injury case can provide something that a trial cannot guarantee: immediate and certain relief. If you've been hurt in a car wreck, you probably have medical bills that need paying and perhaps no income coming in while you're recovering. A settlement puts money in your hands now, whereas a trial verdict, even a favorable trial verdict, can be years away. That faster timeline can literally be life-saving when you're facing costly treatment or rehabilitation expenses. With a settlement, you also get certainty. You know exactly how much compensation you'll receive, and you can plan accordingly. There's no stress about what a jury might do, no waiting through deliberations, and no appeals to drag things out further. It's a bird in the hand scenario. Many of my clients find that accepting a fair settlement brings a sense of closure. They can finally exhale, knowing the legal battle is over and they can focus on healing. Especially in a car accident case, reaching a settlement can bring peace of mind. You avoid the nightmare scenario of going through a full trial only to get a disappointing result. That doesn't mean you should ever accept a lowball offer. You don't want to do that just to be done. But when the offer on the table is fair and covers your needs, taking it can spare you months of anxiety and uncertainty. As one Florida law resource put it, in most cases, it just makes more sense for both parties to settle and avoid court. particularly if the insurance company is putting their policy limits on the table. There's often no benefit to dragging it out at that point. A fair settlement allows you to move forward and rebuild your life without the ordeal of a trial hanging over your head. When trials do happen, and why having a trial-ready lawyer matters. Now, even though most cases settle, there are times when going to trial is the right call. For example, if the insurance company refuses to offer an amount truly reflecting your damages, perhaps they're denying liability or drastically undervaluing your pain and suffering, we may need to take your case to a Florida jury to seek justice. A trial might also be necessary if there's a big dispute over who is at fault or if critical evidence needs to be weighed by a jury. I always tell clients, settle when it's fair, but don't settle for less than you deserve. The good news is, when you have an attorney who is fully prepared to go to trial, it often helps you settle. Why? Insurance companies in Florida know which lawyers actually fight for their clients in court. If they see that you've hired a firm with a strong trial record, they have extra incentive to put a reasonable offer on the table. They won't want to test a confident trial lawyer in front of a jury. So while our goal is to resolve your claim efficiently, we prepare every case as if it will go to trial. This approach protects you. If the other side won't budge, we're ready to fight for you before a judge and a jury. And if they do budge, it's often because we've shown them we mean business. In short, trials are the last resort for personal injury cases, but sometimes they're the only way to get full justice. By understanding that most cases settle and why they settle, you're better equipped to make decisions as your case unfolds. It's all about weighing the risks and rewards with guidance from your lawyer, and make sure your lawyer is a trial lawyer. If you found this information helpful, you'll definitely want to catch our next video, the 5 critical tips to maximize your car accident settlement right here in Florida. In that video, I'll walk you through exactly how to get the most out of your claim, from preserving evidence at the crash scene to dealing with insurance adjusters, all tailored to Florida law. These are practical, must-know tips to help protect your rights and ensure you don't leave money on the table, even if your case settles, as most do. Following those tips can make a huge difference in your final recovery. See you over there.